Every Tuesday, we do bring in immigration updates and we take live questions from 5 p.m. to 6 p.m. Central Time. Along with me is my business partner, Emily Newman. What do we have today to discuss, Emily?
We're going to start out today talking about President Trump's recent comments at an AI summit in Washington, D.C., where he urged major tech firms to stop hiring in India, focus on hiring American workers. What does that mean for people from India who are in the US on H-1B, other visa statuses? We'll also talk about where we're at with the notice to appear issues, what you need to do if you received one of them, what are your options? Um, We'll talk about the PERM application process. If you are in that recruitment phase and your company says we can't complete recruitment for various reasons, what do you need to do? What are your options? What timelines do you need to be aware of? And then lastly, we'll talk about salary issues while you're on H-1B and how it can impact your extension or even your transfer if the salary listed on your pay statements and W-2s is not in line with what it's supposed to be according to your LCA and I-129 previous filing.
Coming to the discussion of don't hire Indians, will that have any impact on the existing people who are in USA who are working on H-1Bs, L-1s, or probably on EADs and OPTs and STEM extensions who belong to Indian descent, Emily?
Well, I think that it could, as we are seeing more firms moving jobs abroad, and I think that's what Trump was trying to focus on was stop hiring people outside the US, hire people inside the US instead. But at the same time, they're making it so difficult to hire the workers that we need in the US that it is sending jobs abroad. And the fewer jobs we have in the US for Americans, the fewer jobs are going to be there for foreign workers as well. So that's kind of the impact I could see. We still just have Stephen Miller behind everything, who's just anti-immigrant in general. So I do think we're going to see continued tightening of H-1B. We've already got a proposed regulation coming to change the lottery system. We've got the new USCIS director who wants to make sure that the H-1B program is, what did he say? Supplementing, not supplanting American workers, I think was his comment today or very recently on that. So I think more is coming when it comes to H-1B.
And also, don't forget, Emily, that we did discuss about stamping in the Dropbox. It's a delay in stamping in the consulates also will be having a negative impact. I think so. When Trump is calling, do not hire Indians, it eventually, because of the restrictions that they're putting here in the United States, the ones that you discussed, and the more things that are coming in, will eventually lead to hiring more Indians definitely outside United States instead of inside United States because of the tech talent that are available outside United States. It's becoming very tough to bring them into United States and employ them into United States. We have more FDNS visits. We have more scrutiny on the companies politically hiring people of H-1B in United States or other non-immigrant visas. We have a lot of scrutiny on the green card applications right now getting failed in the recruitment process, and we have more restrictions coming on the H-1B, not just H-1B, but entire immigration. The anti-immigration feeling that probably will encourage these companies to go outside instead of having the US jurisdiction, because once they establish a business in outside the country, they do not come into the immigration clutches of United States. They can freely employ people whom they want to in other countries. So they don't have that restriction. So this call will eventually lead only more. This administration is eventually going to lead more hiring people outside the country, outside United States than in United States. And that's what my feeling is.
Yeah, I mean, we still definitely need foreign talent, essential to American competitiveness, especially in these emerging sectors like AI. There are just not enough US kids going to school for those types of things. And the amount of jobs are still there. There's still plenty of work out there. It's just changing. What the job looks like is changing. The skills that are needed is changing, and we need to be able to keep up with that. And the only way to do that is to get the top talent from around the world, not just in the US.
Emily, about a month ago, we reported a notice to appear first time when we got a couple of cases. And it seems that all other people are also reporting the same thing, what we reported a month ago, that people who are in legal status are getting the notice to appear, which eventually they will have to fight the case in the deportation proceedings, where they have to hire a local lawyer, request the judges to dismiss the case. We are noticing some positive results, especially when they are going to the judges, as long as there is a reasonable prosecutor there or reasonable lawyer from the government, they're able to dismiss where they're filing a joint motion to dismiss the case. The judges accepting in most of these cases. But still, it's a lot of strain for these people where they have to go to the deportation proceedings. Can you report in the past 1 month, what is the new developments right now? What do people need to do if they get the deportation notice? Emily, there are some cases where people have not received the notice to appear in the deportation, but they got the deportation directly from the court where you didn't appear for the notice to appear, so I'm sending you deportation. What do they need to do?
Yeah, I think people, number one, need to make sure that their address is always updated with USCIS through the AR11 form, whether you mail it in or fill it in through your My USCIS account. That's very important because, as you said, we've seen where the NTA was sent to an old address, the person wasn't aware of it, didn't receive it, and the next thing you know, he gets a final order of removal in absentia saying, because you didn't show up, we find all the allegations that the government made in the notice to appear to be factually correct, and therefore you are removable, and we're therefore removing you. And that is a huge hurdle to have to deal with on top of just getting an NTA. It makes it even more crucial. So make sure your address is updated. Monitor the case status of your previous I-797 receipt notice. Like if you've left the company, stay in touch with that company, find out if and when they're going to send a withdrawal request to USCIS. Um, and then check the online case status for that case to see if it mentions anything about correspondence received or revocation notice sent or confirmation of withdrawal sent. Um, if you have an A number, you can check your A number through the EOIR website to see if there's any court date listed for you. If you don't have an A number, we've not come up with any solution to be able to monitor that aspect of it. Beyond that, if you do receive a notice to appear, I would number one, make sure you get a local attorney who is very familiar with the court where you've been asked to appear and handles removal and deportation proceedings. I think it's important that people continue reaching out to USCIS, to their congressmen, to their senators, to bring this issue up. It looks like AILA, the American Immigration Lawyers Association, is now aware of the trend. They've put out a call for examples to their members. So as more attorneys are reporting these cases, AILA will hopefully reach out to USCIS about it. I have personally sent emails to anyone I could think of in USCIS, but one of them actually did respond back to me, asked for more information. We've had several emails back and forth, so I'm hopeful that they are understanding the issue and aware that they're not following the guidance of their own policy memorandum that was put out in February about when they should be issuing these NTAs. So the more we can bring it to the right people's attention, we will eventually get this corrected, because it's so clearly wrong. And it just seems to be that, USCIS just doesn't know its own rules. We have multiple people who've gotten these NTAs where the NTA is saying you're charged with remaining in the US beyond the period authorized on one hand, and on the other hand, the same USCIS is sending them an approval notice for their change of status or their transfer, saying you're authorized to stay. Here's a new I-94, good for the next 3 years. Same agency, same person, same situation, completely different interpretation of facts. So it's just so clearly wrong. The fact that these NTAs are getting overturned in immigration court is certainly a good sign, but we need to nip this in the bud and stop them from sending them in the first place, because obviously this is a huge impact on the immigrants themselves who've done everything correctly and are lawfully here. Now they have to hire yet another attorney and appear in immigration court. And that's just a lot of stress and unnecessary burden that we need to um, get taken care of. So we do have a blog post on our website, rnlawgroup.com, that gives you instructions for sending letters, for sending emails. Copy and paste is very quick and painless. And the more people that do that, the more we can get this to the attention of the right people and hopefully stop it from happening further.
And it's a very good draft Emily has done for you to send it to the congressman, to the DHS authority, the Department of Homeland Security authorities, and all those things. And you can expect, especially when you describe your situation, you may expect a response from them. So please go to rnlawgroup.com in the NTA. Emily has put those things. Please use that. It's available. It's put for you to use it. Emily, as you know, the job market is getting tight, and the PERM application, the rules for the PERM application, I just want to let you know that PERM application is the one what you need to get it approved for you to file an I-140 application to establish a priority date and probably to extend your H-1B beyond 6 years, and for some people, maybe even get the green card through the priority date. Now, for the PERM, though, the companies have to prove that there is no American worker available that is willing to join for this particular kind of job. Now, of course, typically in the industry, though, people hire the best and the brightest that is available in the market. Of course, Reddy Neumann P.C does, and every other company that we know of normally hires the best available candidate that is available in the market. Now, when it comes to the PERM labor certification, the rule is very clear. The minimally qualified person has to be hired. And if they don't hire the minimally qualified person, then they cannot continue with the PERM labor certification. That's the general rules of the PERM. I'm not telling that's the rules of the industry. The industry, as I know about, is that they hire the best that's available. But when it comes to the PERM, it's the minimally qualified person need to be hired. So when they do the recruitment, like advertisement in certain blogs and what the PERM requirement advertisement, when they do get the applications, if there is a minimally qualified person and they don't hire that particular individual, the company cannot proceed for the PERM labor certification. Now, Emily, so sometimes the companies fail because there may be minimally qualified person available for the kind of job for which they advertised. Now, what from the employee's viewpoint, as you know, that the 6th year is going to come to an end, and unless the recruitment result goes on properly, the company cannot file the labor certification. What are the steps that the employee can do at this point of time?
I think the best thing is to look into options where the PERM labor certification is not required. There are a few categories where you can get an approved I-140 without going through the PERM labor certification process. And that I-140 just works like any other approved I-140 that allows you to extend the H-1B beyond the 6-year limit. So one of the great options for that is the NIW, or National Interest Waiver, in the EB2 category. You do not need a prevailing wage determination, which cuts out about 5 months worth of waiting time. You don't need the recruitment process, that cuts out about 6 months of the waiting time, and you don't need to file the PERM, which cuts out about 14 months of the waiting time. Now, you do need to be working in a field where the work that you propose to do is going to be in the national interest. You do need to have a master's degree. So not every job is going to qualify for it, but that's definitely a great option to get a faster I-140 approval without having to deal with PERM. Another option is the EB-1A category, where you don't need a perm. You can even self-sponsor. The NIW you can self-sponsor as well, but either one of these can go through the company. Um, Obviously, EB-1A, extraordinary ability, it is a much higher bar. You've got to show that you're top of your field, cream of the crop. Those are getting harder to get approved right now, but it's something to potentially try to build up your resume for if you're having trouble making it through the perm labor certification process. EB-1C, maybe you worked for the company abroad, maybe they brought you over on an L-1B, but maybe now they're able to promote you into a managerial role. And if your role abroad was managerial, you can then qualify for the EB-1C category. That only works if your role abroad was managerial. If it was specialized knowledge, it does not work. Um, Other options to look into are maybe EB-5. It's the only category that is still current for India, to where you could file your I-526 and your 485 today if you are wanting to do that. Obviously, $800,000 is a bit of a stretch for the investment amount, but that is also an opportunity. Other things to consider if you do have to go through the perm process is, the company can wait 6 months and test the labor market again. They could also consider sponsoring you for a different position. It's not mandatory for them to sponsor you only in the position that you currently hold. Maybe they can offer a different position that's a higher level, that has more experience requirement, different special skills, that has a different labor market at this time, that's not as impacted with qualified workers that may impact recruitment. So those are some of the options to look at, as well as just buying more time on your H-1B by traveling, recapture that time, changing status to another category. Maybe your spouse has on H-1B and has their own approved I-140. You can switch over to H-4 and EAD and continue working towards making your own perm and your own I-140, but without the same time deadline that you have to worry about.
A couple of other suggestions that I would suggest is probably if you can find a different company that can file a labor certification. You don't have to stick with the same company that can, you don't have to stick with, you don't have to have the company that you're working to file a PERM. You can have a different company to file a PERM from a different location. There is also another innovative ideas, which I probably did it about 30 plus years ago. My wife was employed in a city called Atlanta, where the job market was a little bit different than that of when we actually moved to a city called Childress, Texas. At that point of time, when we moved to the city called Childress, Texas, from where my wife's labor certification was filed, there was no McDonald's in the nearby 70 miles. There was no movie theater by nearby 70 miles. There was no highway for the nearby 110 miles. Definitely, when they tested the labor market, she was the only OT available in the entire nearby 40 miles radius. She was the only occupational therapist available at that point of time, kind of very similar to physical therapist at that time. So definitely the labor certification got through without any trouble. So that's something that you can think about if you can find a job in remote places, because the labor market does test only the local market, not the entire nation. So you can think about all these creative ideas. Emily, now, when the people come into the United States, some of the consulting companies, we notice that, let's say, for example, their paycheck of May comes in the month of August sometimes. Even though I haven't seen any difficulty in getting the have you seen any difficulty in getting the H-1B approval when the paychecks has been delayed? The paycheck is dated in August, but it says that they're giving the paycheck in May.
Not yet. I have seen this issue come up in wage and hour audits, from an LCA standpoint. That's definitely a major delay. But I do think that USCIS is looking more closely at pay statements when you're filing an application. We have seen recently requests for evidence regarding maintenance of status, where they look at the pay statements that were submitted and see that the year to date pay seems less than what is mentioned on the previously approved I-129 and LCA. Um, with their intention that they might deny the extension of stay. They can still approve the petition, but deny the extension of stay, meaning your I-94 is not going to be there. It's consular processing. You have to exit. You have to go for visa stamping, which is now going to be a big problem, and then come back. We also have started seeing this in transfers. Which never had happened before, because typically when an H-1B transfer is filed, it's a new company filing it that has no relation to the person's old company. They have no control over what the person's pay was at the old company. But now USCIS is looking at the pay statements and saying, hey, we think you were not maintaining status with the old company because of issues with your paychecks. So I do think it's potential that delays in the salary, where the dates, the pay period versus the actual pay date, are a huge discrepancy. Have you seen any issues with that so far?
Well, I'm sorry, Emily, I didn't pay attention. I was reading the questions.
Oh, that's okay. Have you seen issues with people with that the delay in the paycheck compared to the pay period, where it's like 2, 3 months delayed?
I haven't seen, especially in the H-1B transfer, I haven't seen it though. What I've noticed, Emily, is that these companies who are doing this one, though, when they leave the job, they don't pay the last 2 months.
Mm.
They have a habit of not paying the last two paychecks. Now, if they do that, though, what I want you to do is that once you transfer to a different company, there is a form called WH4 form. Now, if you threaten the company, you call the company, they won't care. Now, when you do a threatening, though, you better threaten them properly, though. So the way to threaten is that you fill out a WH4 form. Hey, this company didn't pay me the last 2 months that I worked. And then you give them all the details of that in the WH4, Department of Labor, WH4 form. You can Google it out, you'll find the form. You fill that form out, you send to the employer, dear employer, pay me this money. Otherwise, I'm going to send this complaint to the Department of Labor. Boom, that comes immediate response from the employer. If it doesn't come, just send a complaint to the Department of Labor. They will get you the money if the company is still there. Otherwise, they'll close the company. So you can do that complaint. Anything else, Emily, before we go to questions?
No, I think we can go to questions.
Questions coming from Mazid and Joseph, and a suggestion from Kishore is that, do I need to carry the green card everywhere I go? Kishore is suggesting that there is a Twitter from CBP to carry the green card wherever you go. We did advise people, we probably advised a lot of times not to carry, but the circumstances have changed. We told people only when you're going to the border towns like South Padre Islands, or probably in the Key West, south of Miami, those kind of places. We told people to carry the green cards. But now I am suggesting people to carry the green cards, just like the way you carry the driving license, you carry the green card. I also want you to give the copy of the colored green card to your spouse, couple of your cousins, so that they can keep it with them just in case if you lose, or you can find that green card. And then that can be immediately provided, or keep also a copy of it, a digital copy of it, to show to any of the people. What do you say, Emily?
Yeah, I mean, I understand the fear of potentially losing that document and the difficulty of replacing it and all that. But to me, it's not much different than the fact that I carry my driver's license with me everywhere I go, even though I might lose it, and it's a hassle to replace it. So I think it's a good idea to carry it, especially in just the current environment, with who knows what's happening with ICE and where they're going to be, and always good to have it.
And for you to get the replacement of the green card is not the same as getting the green card. Trust me on it. It is very easy for you to get the replacement of the green card. You go online, you fill a form called I-90, and you will get a document that will tell you that you have filed for the I-90 that will allow you to stay, that will work as a green card for you for the purposes until you get the green card. And it is not that tough, guys. It's definitely not that tough for you to get it. You can get the green card replacement without a need for the lawyer. I mean, practically, people come to me, file for my green card renewal, or I lost my green card. What am I going to do? I'm going to just type in your name and date of birth and charge you the money? Well, charge me less. No, sorry, my time is valuable. Just type your date of birth, your A number, which is there on your green card, and then provide it, please. It's so easy for you to get if you lose the green card. So, not a big deal. Do you need to have a police complaint? No, you don't need to have a police complaint. You can just file it, not an issue.
All right, we may have lost Raul there, so we'll keep going. Best Friend
Sorry for
Vlog
the
says,
disturbance. So you can get the duplicate green card without much trouble.
Best Friend Vlog says, are we seeing increasing instances of
Emily.
RFEs or denials since the new USCIS director has taken over? Not yet. It just happened like a week ago, so it's definitely going to take time. But that being said, we have seen new types of RFEs coming, not just since the new director has taken over. So we are seeing issues with, the biometrics that we talked about before, where people file an I-129 or an I-140, they get an RFE mysteriously telling them they're going to have to go for biometrics and to reply back once they go for biometrics. Now we're seeing the next step in these cases where for most of them, they have some sort of law enforcement encounter. Many of them are DUIs. And they're being asked to submit the documentation of what the arrest was, the police report, the outcome of the case, the disposition in the court. In most of the cases, they just ask for the documents and nothing further. What we are doing in our office is assuming that they're going to question whether these documents make the person inadmissible. So we're making the argument that based on the potential criminal conduct, this person is not inadmissible for the following reasons. But we're then going one step further and discussing the positive discretionary factors of giving this person the extension of stay or the change of status requested, because USCIS is now claiming that they have discretion to deny an extension of stay or a change of status based on negative factors. And so they're using these arrests as a negative factor. So we need to provide all the positive factors. So that's kind of where we're at with those. We are not seeing outcomes of those yet. Another area of RFEs is regarding deference. So the Biden administration finalized the deference policy that said that if you previously were approved for a certain job and certain terms and conditions of employment, and you're filing an extension with the same company under the same terms and conditions of employment, USCIS will typically defer to that prior approval, and you don't have to reprove everything again. They will agree with their prior approval and approve you again as long as circumstances have not changed. Recently saw a request for evidence saying that, not really explaining why, but saying that we're not going to apply deference in this case. And then going through, is this job a specialty occupation, even though they've previously approved that position for a specialty occupation. So we may start seeing more of that as well. So I think whatever USCIS is going to be doing when it comes to legal immigration, we're just getting started. And we're going to see a lot of changes over the coming months and years based on the new director, as well as Stephen Miller's involvement with the Trump administration. All right. Zoomer says, I'm working with TN visa for EB3 green card sponsor, who I have to work for 2 years, which will end in October. Priority date is not yet current. Can I change my employer in October 2025? So Depends on a couple of things. Having an I-140 approved is not the only factor when USCIS is determining whether you have immigrant intent or non-immigrant intent that's required for the TN visa. So they're going to also look at your intention to return to your home country. Do you have a residence abroad to return to? Are you planning to only stay for the next 3 years based on this employment? Was your I-140 approved for consular processing, or was it intending for adjustment of status? All of those factors come into play. So it may not be a great time to change employers if you have that immigrant intent issue. It might be better to continue with your current employer until that expires and hope that your priority date becomes current before you have to file again. Anurag says, my current I-797 and visa is stamped to September 2nd, 2025. The extension's in progress. I traveled to India and my extension status changed to cases still being processed. Shall I cut my trip short and return now? Um, Case being processed versus case still being processed, there's no difference between that. They're just haven't done anything on the case yet. So it doesn't necessarily mean anything bad. You should be able to return before September 2nd when your visa expires, regardless of what's going on with the extension. Gayatri says, my spouse is on L1B with an approved I-140. He was promoted in April, but no L1B amendment was filed. His H1B was also picked in the lottery, and that has an RFE on it. Could the RFE be due to the promotion? Very unlikely. Not all promotions require an amendment, especially when it comes to L1Bs or L1s in general. If the position still requires and involves specialized knowledge, it still qualifies for L1B. So it's probably not related to that at all, would be my guess. Chandra says, my I-140 was approved in June. Can I switch the job now? I mean, technically, yes, but it's probably not a good idea to do it because if your employer, after you leave the company, withdraws your approved I-140 and the I-140 has been approved for less than 180 days, you will not be able to use that approved I-140 to extend your H-1B beyond the 6-year limit with the new company. Your spouse won't be able to keep using it for H-4 EAD extensions as well. You do get to keep the priority date, but you lose the H-1B and H-4 EAD benefits by switching the job too soon. Now, if this is your second I-140, maybe you have a previously approved I-140 that's been approved for more than 180 days, then there's no issues. But if this is your only I-140, now is not a great time to change jobs. Pokiri says, will any questions on here be detected by Palantir software? And should people avoid asking difficult questions in social media that could get in trouble? That's a very good question. I mean, I think Palantir has a lot of power and does a lot of data analytics to try to put two and two together with things. So I probably wouldn't be going on here saying that I've committed a crime and now what do I need to do for my immigration, or I am undocumented here or out of status or things like that. Um, and obviously don't share personal details on here as well. Um, Denise says, my husband's H-1B got approved with premium processing. When will the H-4 get approved? My status is case is transferred to another office. Yeah, we're seeing that a lot right now, unfortunately. Um, we are seeing delays in the H4, delays in the H4 EAD. It may take a few months. It's all over the board right now. Some are getting approved just a few weeks after the I-140, I'm sorry, after the H-1B is approved. Some are taking several months, unfortunately, especially with them being transferred to another office. I don't know why they're doing that. When the H-1B is approved, they should approve the H-4 along with it, but they're starting to separate them again.
Sorry for the technical
Sure, go ahead.
question from that. Since the new director has come, have you noticed more RFEs or have you noticed more denials in the
I got that one
USCIS?
already.
Okay, sorry about that, Emily.
That's okay. Lucky Luck says, can an L1B holder continue working on L1 after receiving the H4 and the H4 EAD? Well, once you receive the change of status to H4, you're no longer in L1, you're on H4. But if you've also received the H4 EAD, now you can keep working on the H4 EAD. If you want to continue the L1, you need to either file a change of status back to L1, or if you have the L1 I-94 validity and the job offer remains with that company, you could potentially travel to Mexico, do the Margarita switch, come back showing your L1 visa stamp, your L1 approval notice with the I-94 that's still valid, and then continue working on L1B and keep the H4 and H4 EAD in your back pocket.
Question with regards to if I do the double masters, do I need to go for stamping? First, if you have the stamping validity, though, technically you don't need to go for stamping. But if you're stamping, normally a passport stamping for F1 is valid for 5 years. If that's over, then you have to go for stamping. And this time will be an interview. And the other problem is that, especially for the people who are going for double masters, it's going to be very tough for them to get the F1 stamping because they will question why do you need to do two masters? Unless it's from a very reputable university, though, I would tell people not to go stay in United States and do the masters.
Spartan says, I work for a very small company with 4 employees. I want to travel to India for a family emergency. I have an H-1B extension. You really need to consider the importance or seriousness of this family emergency against the potential that you may be stuck outside the US for a long period of time and lose the job. Not just because you work for a small company, but we have a new policy beginning September 2nd, which now requires an interview in person for every single person applying for the visa. The drop box is gone for H-1B. The drop box is gone for H-4. So you may have a very difficult time getting a visa interview appointment. For one, might take you weeks or months. On top of that, once you have the interview, we don't know how long it will take for the visa to be issued if they're having to interview every single person. We don't know if there's going to be a 221G because the company is a very small company. They're going to be re-looking into all the issues that the H-1B petition mentioned. So they're going to be trying to make sure, are you actually working in a specialty occupation, which tends to be an issue sometimes for small companies because they think that you're possibly doing more than just the specialty occupation work because there's so few employees of the company. So definitely need to really consider, is this truly a family emergency?
Okri from YouTube is asking the question, I-140 has been approved with Company A in 2018. I'm assuming that it's not been withdrawn for a period of 6 months after it's been approved. It doesn't matter if they withdraw it after 180 days, it won't matter. But if they're not withdrawn, which I'm assuming it's not withdrawn within 180 days, the new company, which is working with Company B, has not filed the green card for a PERM application or I-140, is there any new changes in the law or implementation at this point of time that he should be worried? So his question is that if the new company doesn't file the permanent labor or I-140, can he keep on renewing the H-1B beyond 6 years? Can he get his spouse the H-4 EAD? Can he can he put the date of 2018 at a later date to a different company, or maybe it's the company C? absolutely nothing has changed for you at this point of time. Nothing has changed. You are good as what you were about 3, 4 years ago. Nothing to worry right now. But yeah, keep tuned into our channel, because if there is any updates, we will let you know in this one. And also, you can subscribe to our RN Law group, where uh, if there is any such news that pops up, any new regulations, any new laws, any new things that develop, we do put out so that you can get that information immediately, so that you can take necessary action. But as of now, nothing to worry about it.
Timothy says, I'm currently on H1, also have a valid GC EAD, and I'm about to complete the 60-day grace period. Is it a better idea to file a change of status to H4 and H4 EAD, or just use the green card EAD? What are the risks of using the GC EAD versus an H4 EAD? In the current environment, it may be a better idea to go ahead and file the change of status to H4 and get the H4 EAD. That just gives you an extra layer of protection against all the crazy things that the Trump administration may do. If they, for some unknown reason, deny the 485 and you were using the GCEAD, you're immediately out of status, immediately unlawfully present. If they deny the 485 and you have the H4 status, then you're still in H4 status. Then you have more time and breathing room to be able to file a motion to reopen or file a lawsuit or whatever you're going to do about that 485 denial. Now, in general, in prior years, we would say that you usually don't need to keep that non-immigrant status. You can rely on the adjustment of status. You can use the GC EAD. And most of the time, that's fine for most people. If they've already got the I-140 approved, there's no criminal issues, there's no prior immigration violations or status issues, it's relatively safe. Now we want to be even more safe, and it's probably a good idea to keep the non-immigrant status going.
Emily, this involves a little bit more discussion. From SK from YouTube is asking the question, what right legal immigrants have in United States against all such negative policies, and we know what those are, which keep coming. Now, I don't, so I would say that each policy should have to be taken independently. For example, if they are saying that visa stamping Dropbox is not available, I don't think so. There is any legal thing challenges we can do. But if they are denying the H-1B wrongly, or they're issuing an NTA when the people are allowed to stay in United States, those can be challenged in the court. If the immigration does not adjudicate the applications in our favor, they can be adjudicated. But what other legal rights people have, immigrants have, Emily?
Um, you can reach out to your congressman or senator's office. Even though you can't vote for them, you are still a constituent if you live in their district. You can reach out to USCIS, like we talked about at the beginning with sending emails, dealing with this NTA issue. And you do have the right to seek redress with the courts. Um, so yeah, it all depends on the policy, and it certainly there's a lot of negative things happening right now, which is to be expected under the Trump administration when people were excited that he talked about stapling a green card to your master's degree. We tried to warn people that don't rely on it. It's not going to happen. Things are going to get bad. And we're starting to see that now. And it's just going to be a matter of waiting until the tides change.
A question from Krishna Suram is asking the question. We live in Delaware. My son is going to college in Indianapolis this August. We are green card holders. I understand that we need to carry the green card at all times. What else that you need to take care of? Definitely driving license is something that I would say. Keep updating the driving license. Nothing else other than these two things. If you ever travel outside the country for more than 6 months, definitely speak with a lawyer before you travel outside the country for more than 6 months. Everybody has to file income tax returns who are a green card holder. That's a law. So even, and people ask me the question, no, the IRS says that only if I make more than some $10,000, not the exact figure, but $10,000 I have to pay income tax. Now, IRS rules are different. The immigration rules are different. You have to file income taxes. Now, if you make zero income, zero, zero, you can put everything zero and file income tax returns. That's perfectly all right. One other thing that we suggest people for the who are green card holders is definitely please apply the citizenship. We have been told that the number of people who are applying citizenship has gone up significantly. And I would thank for Trump administration for that because we don't want you to be on the green card for a long period of time. Now, there are things like, you know, that in a normal green card, where if you're not married with a green card holder, that you can file the citizenship in 5 years. But please note that you can file within the span of 90 days before the 5 years. That means, let's say, for example, if you got a green card in 2000 September, and that means that by 2005 September, you will be eligible for citizenship, but you can file within the span of 90 days. That means right now in July 29th, you will be eligible for to file the citizenship. Citizenship is not as complicated as green card is. You can file it online, not a big deal. And you can even consult us. We can even look into the form and then make you file online. So if you are eligible for it, don't try to delay it, file it. There are a lot of people that ask questions. I'm a lawyer in India too, happily so. Not though I don't have much experience, but do I have a law license in India too. So they ask a question, oh, I can't own any agriculture property while I'm a US citizen. You can own the agriculture property, but you cannot buy any new agriculture property. You can even inherit the agriculture property from your parents, but you cannot buy new agriculture property. So that's one minus point that you may have. Definitely, if you have any political intentions, you want to contest in any Indian elections, definitely US citizenship is not advisable. But otherwise, all the other people, 99% of the people that I know, don't want to be in those buying agricultural properties or get involved in the politics in India. So definitely you should apply for the citizenship as soon as possible. Don't delay it. Don't delay it.
And Keita says, I'm on H4 and I didn't receive my EAD card after the renewal. I have the valid approval notice of the I-765. My EAD card is expired. Can I continue to work on the approval notice? The I-765 approval notice does not allow you to work. It says right on it that this is not an employment authorization document. It does not provide any status or benefit. However, if your H4 status has not expired, you have the EAD card that's expired. I'm assuming your I-765 was filed before your EAD card expired. Those three documents combined give you the 540-day auto extension of your expired EAD. And you can work based on that while you work on retrieving the EAD card that was approved wherever it went.
Emily, one more discussion that I need to have. I want you to pay attention to what I'm telling. If there's anything wrong, please let me know. This question is coming from Pokri that my friend got a non-protect H-1B. Non-protect. Non-protect means the person went out of status, but they filed the H-1B extension and got it approved. Will it cause any problems at the stamping or anywhere else? The simple answer is absolutely no problem for it. Even though you're out of status, you made an argument of non-protect, saying that please excuse me for being non-protect, and they approved it. And then there's another question that one of the person H4 as extension has been denied incorrectly and they're refiling the H4. Can they file when the I-94 expired? In our website, we have said non-protect. When the person goes out of status, you can file the non-protect. We have filed several non-protects, have been very successful, but Houston, we have a problem, Emily. And we recently got an NTA, notice to appear in the deportation proceedings, when the person filed a non-protect. Because in non-protect, we are admitting to the USCIS that we are not in legal state assembly, and we got some NTAs for the people who applied for the non-protect. What do you recommend right now when people are to apply for non-protecting. Non-protecting means excuse me for being out of state, out of status, or unlawfully present in the country.
Yeah, I think we have to weigh the risks of the various options. Um, if you're not doing a nunc pro tunc, your other option is generally going to be exit the US, apply for a new visa stamp, and come back in. The problem with that can be in some cases, if your I-94 expired more than 180 days ago, when you exit to fix everything, you're going to trigger a 3-year bar to being able to come back. You're inadmissible for the next 3 years. If your I-94 expired more than a year ago, and then you leave to fix it, you're going to trigger a 10-year bar. Then you're going to need a waiver if you're going to try to come back before the 3-year or the 10-year bar. So you have to weigh that issue versus the likelihood of getting an NTA by filing the nunc pro tunc. So for someone who has not stayed up to 180 days, their overstay is less than 180 days, I think travel might be a better option to solve the problem, because then you're not triggering anything and you don't have to worry about this potential NTA issue by filing a nunc pro tunc. But if you're beyond the 180 days, to me, there's not really a choice. Do I want to leave and spend the next 3 to 10 years outside the US stuck or waiting forever to get a waiver? Or do I want to take my chances and file this nunc pro tunc that has, in a case, in maybe a few cases, caused an NTA? We have to monitor the situation. It is a low number of cases that we've seen this in. I think the other thing that we're going to start doing in our office when we file these nunc pro tunc cases, because the whole idea is we're asking USCIS to use their discretion to put the person back in status as if the delayed filing never happened. So it is discretionary. So now we get back to what are the discretionary factors? A negative factor is the fact that this person has technically overstayed. So what are all the positive factors that outweigh that one negative factor that we can point to? So we're going to be starting to include those discretionary factors in our nunc pro tunc filings to again urge USCIS to use that discretion positively to issue the extension or the change of status.
Jay Kumar got an NTA issued even though he is in legal status. He's thinking it's a processing error. Is there any way he can contact the higher ups in the DHS office to resolve it rather than going to the courts and doing the proceedings? I definitely want you to do both the things, Jay. One is you need to hire a local lawyer to defend yourself, and then try to go for higher authorities, contact the higher authorities. How to contact the higher authorities, especially when you are on a legal status, especially when you are in H-1B and your H-1B was been withdrawn after you left the job, and now you are in a different status with a different company or probably in a different status. There is a very good write-ups where you can contact and contact information of the higher ups. Emily has given provided. I did put out the link. I don't know if you can access it. If not, you can go to rnlawgroup.com, and then they can go there and do it. Jay Kumar, if it's not for you, whoever it is that NT is, yeah, they can contact the higher authorities. And even if Jay Kumar is saying that it's not him, but even if somebody else, though, you may want to give this attention to the immigration authorities, higher up authorities, that this is happening, so that it doesn't happen with you or anybody else who are in legal status. And the draft is put there, and I put a link so you can access it.
Apurv says, is there a way to correct on the I-797, the employer address zip code without filing a new petition? Potentially. Number one, it depends on was the zip code entered correctly on the I-129. And then on the approval notice, they put it in with a typo. If that's the case, then the company or the attorney that represents the company can submit a service request for typographical error and get the corrected approval notice. If it was put incorrectly into the petition, then the only way to correct it is to file an amended petition. Do you need to file an amended petition to change a zip code? Probably not. I don't know why we'd be worried about that.
Speak truth straight on is asking the question: if the green card holder do not have any pro list record and have filed taxes regularly, do you recommend filing citizenship by self, or is it safer to hire an immigration attorney? I normally recommend people to file it by themselves, though. And you can file it online citizenship application if you don't have any criminal records. If you have any traffic tickets, but you have resolved every traffic ticket, and you have not traveled outside the country for more than 180 days on a one single trip. So, if you've combinedly did like 5, 6 trips and they all come to 180 days, that still is fine. So I normally recommend people to file by themselves, though. But if there is any a little bit doubt about the things of any nature, then definitely go with a lawyer. But otherwise, it's not required.
The best aura says, I've switched employers after 180 days. It's a similar role. This was an EB1C. I've not yet filed the supplement J. Are there any issues with traveling to home country and returning on advance parole? No, the supplement J, there's no deadline to file it. So there's no requirement that you have to file it in order to use the advance parole or in order to travel or in order to use the EAD or anything like that. Just if you are traveling, make sure you're monitoring your case status in case an RFE is issued while you're out. And if they do issue an RFE for the supplement J, make sure you have it in time to reply back.
A lot of debates with regards to whether, giving up the immigration process, you're going to visit India. But that's more of a personal choice, though. It depends on what kind of family background you have. For example, I come from a very humble background. When I was in the 11th grade and 12th grade, I used to work in chicken center. I used to be a butcher while I was going to high school at that point of time. Definitely for me, US is very prized item for me. I would not just leave and visit and risk my immigration status if I were you. That's the background I come from. But of course, if your dad and mom has a Ferrari and you have a villa in Kokapet in Hyderabad, and your dad is ready to give that villa to you with a Ferrari or even an Audi car, definitely, US may or may not be worth for you, but definitely for those people who come from humble background and who are trying to save some money and want to work very hard, definitely staying in the United States, not risking the immigration status is what I strongly recommend. So when people consult the lawyers, though, you probably need to pick the lawyers that fall in line with you, though. For example, I come from a humble background. Maybe some lawyers come from a very super rich background and they don't care, staying here and staying in India. They may be having a different environment, but I come from a very strong viewpoint to not risk the immigration status. That is how I treat every of my client, though. When I give advice, also that would be my utmost attention that I pay that they don't take risk on the immigration. So definitely each lawyer is different. I'm not telling that the other lawyer is not good. I'm good. Everybody has their own. Everybody has their own opinion. And within our own office, there are some lawyers who advise differently than I do. So nothing wrong. And this is for the comment for the local bias. I'm responding to him.
Meyer says, I'm on H-1B with an extension and transfer pending. How can I travel within the states with no valid ID because my current I-94 is expiring in September 30th, 2025? So yeah, we definitely have a lot of states that even though you have a pending extension, you are lawfully present and authorized to work for up to 240 days, they won't issue the renewed driver's license based on the receipt notice. They only want the approval notice to issue the driver's license. So number one, I would say your passport is still your ID. You can use that to travel if you mean travel by air. Now drive, no, you should not drive without a license if that has expired, but you can still use your passport as your valid ID while you're in the US. And if you're not expiring until September 30th, there's plenty of time to upgrade to premium processing and get that approval before your I-94 expires, so you don't even need to fall into that situation.
Ricky is saying that he lost his green card, but it took 13 months for him to get the replacement back in 2016 and 2017. We have seen some cases they do give the green card very fast. Some cases it may take a little bit longer time. However, they give a document to you which will allow you to stay in the country. You can even get the passport stamping that will that will work as a green card whenever you go. But then it's a bigger document than that of the green card. That's the only difference, though. Um, Ravi has this question. I have completed 5.5 years of my L1 visa, L1A visa. He has 1.5 year left. His priority date at one point of time was current, so he filed for the 485, got the EAD for 5 years. Do you advise him to move to EAD and apply for advanced parole? First thing is, please apply for advanced parole ASAP. For anybody who is not applying for advanced parole on the adjustment of status or EAD, we strongly advise, even if you need it, if you don't need it, apply it. They're giving it 5 years. Who knows? You may need it later on. That's the first thing that I want you to do it. Definitely, you don't have much options because if the priority date doesn't become current, you don't get the green card by the time you go to the 7th year of your L1. You may not, you have to move on to the EAD. The question is that will you extend? I mean, you get 3 years of L1, you extend it by 3 years on L1, you need to extend 1 more year. Do you recommend extending for that 1 more year? I strongly recommend no, don't extend the L1, just move on to EAD. Why? What if the L1A extension gets denied? I mean, it is possible. You know that EAD, you don't need to do anything. All we need to do is that, hey, you are Mr. Ravi Verma Kalidandi, and you are filing the adjustment of status, which is pending. That's all we need to prove on the EAD. No employer letter, no description of the higher level executive authorities, no job description, no how much percentage of job description, nothing is required for EAD. So definitely, I personally recommend not to extend the L1A beyond what is required. That's what I recommend. I recommend to go on EAD. I personally, when I was in a non-immigrant and had an EAD, I did move on to EAD.
I think we have time for one last question. This is an important one from Vibob. I have my Dropbox appointment on September 5th. I have to travel to India in the second week of August with Dropbox appointments no longer being available. Would I be able to switch from Dropbox to interview? Yes, you're going to have to because your Dropbox will be canceled. The question is, when are you going to get the interview? And I would not exit the US until you have a confirmed interview date, because if you leave the second week of August and while you are out, you find out that your interview is not until December, are you going to have a job to come back to after being outside the US for that long? So I would not travel until I actually have the interview appointment set, and then maybe adjust my travel dates based on that if needed.
Uh, Thank you very much for tuning our, and we do have a daily Zoom conference calls that are available where people can attend. And you can consult with me, Emily, or any of our colleagues. Our appointments or schedule is available online at rnlawgroup.com. Thank you very much for tuning in.